Hello everyone, I'm Michael Bowmer, my name is Ben Patten, and we're welcome to our session on is there no alternative dispute resolution anymore, should mediation be compulsory? So the plan is I'm going to speak for about 10 or 15 minutes, and then we're going to hopefully have a sort of hey on why type session where I'm going to ask Ben some questions. Yeah. Ben's going to have his view, and he's going to canvass views from all of you as to what you think about the latest developments. So I'm going to start by just referring that about 4 decades ago, that great constitutional and public lawyer, Lord Diplock, said that every civilised system of government requires that the state should make available to all its citizens a means for the just and peaceful settlement of disputes between them as to their respective legal rights. The means provided are courts of justice to which every citizen has a constitutional right of access. But just 3 months ago, in the Court of Appeal, the Master of the Rolls, Sir Geoffrey Voss, said this: I would conclude that as a matter of law, the court can lawfully stay existing proceedings for or order the parties to engage in a non-court-based dispute resolution process. And our new Lady Chief Justice and Lord Justice Burse agreed with them. Now, whilst that power is qualified, so that it says, provided the order made does not impair the very essence of the claimant's right to proceed to a judicial hearing and is proportionate, this is, I think, quite a watershed moment, in that this radical new power, which was previously considered by the Court of Appeal to be unavailable, not to exist, has been recognised now for the first time. And it throws up many questions, such as, how have we got here? Is it a good idea? And how's it going to work? And so, as I say, in the course of this session, I'm going to speak to you for 10 or 15 minutes to explain how we've got here to a certain extent, and then we're going to go on to look at some questions and canvass your views. So how did we get here? Well, we've lived with it for so long, and for some of us it may be all we've ever known, which is the CPR was entirely new when it came in 1999, and was engraved at its heart was this concept of the overriding objective, the emphasis on active case management and seeing litigation as a last resort. So hence you see in CPR 1.4, the court must further the overriding objective by actively managing cases, which includes encouraging the parties to use an alternative dispute resolution procedure if the court thinks it's appropriate. Now, allied to that, of course, we had the pre-action protocol. Protocols, that was first the general pre-action protocol, the original form of which came in 1999, and then you had the area-specific pre-action protocols, and you've got the professional negligence pre-action protocol, which came in, I think, in July 2000, both of which have been quite heavily amended ever since. And then you've got wide-ranging case management powers, most notably, for these purposes, Part 26, now Rule 26.5, which confers a power on the court as part of its initial case management powers to stay proceedings for a month or such period as it considers appropriate to allow for settlement. Now, two of the main protagonists of this new culture were Lord Woolf, who was Master of the Rolls from 1996 to 2000, and Lord Chief Justice to 2005, and Lord Justice Brooke, who was Lord Justice of Appeal to 2006. And they both became mediators after they retired, after judicial retirement. Indeed, Henry Brooke became chair of the Civil Mediation Council. And I thought a couple of quotes from each of them from early influential decisions would illustrate their approach. So you had first the Cowell decision, where Lord Woolf said that the courts should make appropriate use of their ample powers to ensure the parties try to resolve the dispute with the minimum involvement of the courts, and that lawyers are under a heavy obligation to resort to litigation only if it's really unavoidable. And then there was the Dunwich and Railtrack case, in which Lord Justice Brooke said that mediators are very skilled and they can achieve results satisfactory to both parties in many ways which are quite beyond the power of lawyers and courts to achieve, and added that if parties turn down out of hand the chance of alternative dispute resolution when suggested by the court, as happened on this occasion, they may have to face uncomfortable consequences. There was a third very influential early decision of Mr. Justice Lightman in Hurst and Leeming, which has perhaps some limited relevance today on the thorny question of whether there's a good or bad reason for refusing to mediate. But he said that alternative dispute resolution is at the heart of today's civil justice system, and any unjustified failure to give proper attention to the opportunities afforded by mediation, and in particular where mediation affords a realistic prospect of resolution, there must be anticipated a real possibility that adverse consequences may be attracted. Now, that trio of cases and others all led up to the seminal case of Halsey, in which the Court of Appeal considered the issue said to be of some general importance as to whether the court should impose cost sanctions against successful litigants on the grounds they'd refused mediation. And there were two conjoined appeals, in each of which an unsuccessful party had run that argument. Now, the Court of Appeal's actual decision was that in neither case was the proposal of mediation unreasonably refused, but it used the opportunity to set out a list of, or to deal with the cost implications more generally, and it set out a list of factors which might make refusal to mediation reasonable or unreasonable. But Lord Justice Dyson, giving the judgment of the court, expressed crystal clear views on behalf of the court on the issue of compulsion. So he said, it is one thing to encourage the parties to agree to mediation, even to encourage them in the strongest terms. It's another to order them to do so. It seems to us that to oblige truly unwilling parties to refer their disputes to mediation would be to impose an unacceptable obstruction on their right of access to the court. Adding also, it seems to us likely that compulsion of ADR would be regarded as an unacceptable constraint on the right of access to the court, and therefore a violation of Article 6. Even if, contrary to our view, the court does have jurisdiction to order unwilling parties to refer their disputes to mediation, we find it difficult to conceive of circumstances in which it would be appropriate to exercise it. Just keep that in your mind, because we'll come back to that. They also added, if the court were to compel parties to enter into mediation, that would achieve nothing except to add to costs, possibly postpone the time when the court determines the dispute and damage perceived effectiveness of ADR. If the parties remain intrinsically opposed to ADR, then it would be wrong for the court to compel them to embrace it. Now, subject to some hardening of the position as to what constitutes unreasonable behaviour in refusing to engage in ADR, that remained the orthodoxy up until 3 months ago. So even in the Jackson report, Sir Rupert said, in spite of the considerable benefits which mediation brings, I do not believe the party should ever be compelled to mediate. And in his review of the civil court structure in 2015, Lord Justice Briggs said, the civil courts have declined, after careful consideration over many years, to make any form of ADR compulsory, adding, this is in many ways both understandable and as it should be. The civil courts exist primarily and fundamentally to provide a justice service rather than merely a dispute resolution service. And he added in that report elsewhere these words, the court underpins most forms of voluntary ADR. Mediation would potentially yield justice to the richer, more powerful or risk-tolerant litigant if the weaker party could not refuse an unjust offer by saying, see you in court. So that remained the orthodoxy. As to that hardening that I mentioned a moment ago, two cases in particular that we're probably all aware of. The first was the PGF case in the Court of Appeal. And Lord Justice Briggs said the time has now come for this court firmly to endorse the silence in the face of an invitation to participate in ADR is, as a general rule of itself, unreasonable. And then the second case was the Garrett Critchley case. And in that case, the court effectively demolished every single argument that the party put up to say that its refusal to mediate was reasonable. And I've identified those 5 grounds that people often put forward. That, well, the issue was binary, it's a liability issue only. That's not a good reason. Odds are all stacked in your favour. Not a good reason. Parties can't stand each other and mistrust each other. Not a good reason. You're too far apart. Not a good reason. Mediation's too expensive, generally speaking, not a good reason. So that was the hardening that took place. Now, Halsey was decided not quite 20 years ago, in the words of Sergeant Pepper. But, so what's happened? We're now told in the Court of Appeal there is such a thing as compulsory mediation. So what really has happened? And I think really three things are responsible for that. The first is some influential European jurisprudence of the ECHR and ECJ. And these are discussed in quite some detail in the Churchill decision. Churchill decision is available in the handout materials online. There were two particularly influential pre-Brexit decisions of the Court of Justice, and considered a compulsory ADR procedure in Italy, and those decided that they did not infringe the European law principle of effective judicial protection. And this is because that ADR process was not binding, it didn't result in substantial delay, limitation was suspended, and there was no fee or only very low fees. And there were similarly cases in the ECHR that suggested that Article 6 wasn't infringed. The second thing, I think I've gone one too far, the second thing is the domestic decisions, and I've mentioned Bradley and Heslin and Lomax and Lomax. In Bradley, that was a boundary dispute, and Mr. Justice Norris said, I think it's no longer enough to leave the parties the opportunity to mediate and to warn of cost consequences if the opportunity is not taken. In boundary and neighbour disputes, the opportunities are not being taken and the warnings are not being heeded, and those embroiled in them need saving from themselves. And then the other one was Lomax and Lomax, which was an Inheritance Act dispute, and the Court of Appeal held that the case management power in 3.12m enabled the court to order the parties to engage in an early neutral evaluation, even if they didn't agree to it. And so Lord Justice Moylan said in that, I see no reason to imply any limitation on the court's power to order an ENE hearing, even to the effect that has to require the consent of the parties. So the third big development, in my view, and most significant one, is the appointment of Geoffrey Voss as Master of the Rolls on the 11th of January 2021. And it's difficult to overstate the impact, in my view, that this has had. And a taste of what was to come came in the McParland case, which you may all know from extended disclosure. That's when he was still Chancellor. But he said in that the Lomax case inevitably raised the question as to whether the court might require parties to engage in mediation, despite Halsey. But that's been followed by a host of speeches and keynote addresses given by Sir Geoffrey in quite a remarkable period of judicial activism. And I've mentioned four of those speeches on the slide, and all of them are attached in the materials, and they make incredibly interesting reading about the future of the civil justice system, or what we should call the digital justice system to come. But the twin themes are effectively of a justice system in which mediation and ADR is completely integrated, and secondly, the development and implementation of what's called a new digital justice system. And what he's driving at is effectively a system of online justice where claimants will log in via a web-based platform, and that will direct them to the most appropriate route, digital route to justice. And there will be effectively 3 tiers. There will be an initial tier where you log in, you put your details in, probably using algorithms and AI, it will work out what the issues in your case are and notify the other side. Then you will go to the second tier, which will be a pre-action protocol offered through ombudsman systems or other systems of personal injury systems or low money claim systems. And that will prompt you to go off to mediation or some other route to dispute resolution at various stages in that digital journey. And it's only if that doesn't result in settlement that you will digitally go to the third tier, which will be the court-based system. So he envisages extensive use of AI, of technology and AI in that process, to identify the issues in dispute between the parties, probably doing away with pleadings. It's one of Sir Geoffrey's big bugbears. He doesn't believe in pleadings. And possibly even predicting the outcome. And he, as I say, envisages mediation being prompted at every single stage of that journey. And they're all in, as I say, the handout, but perhaps I could just refer you to one particular talk he gave. He said, "Let me declare my hand. I think it's inevitable that all civil, family and tribunal litigation will be undertaken through an online system." So that's his vision for the future. And he says, "I think the business and property courts need to be proactive in reforming its procedures for a digital age. We need to look again at the basic commercial dispute resolution process with a view to creating a properly digitised dispute resolution platform, whether that's the existing HMCTS one or the one that I've been talking about." So it's going to come in due course to all litigation. The other thing that Sir Geoffrey did was to commission the Civil Justice Council to complete a report into compulsory ADR. That's the second entry on the slide. And that was published in 2021. And it concluded that there was perhaps a fine distinction between the court staying proceedings for the parties to attempt ADR under threat of a cost sanction and actually ordering them to engage in mediation. And it said there was no infringement of Article 6 so long as the parties remained free to take their dispute to court, and as long as that ADR procedure wasn't disproportionately expensive or took a disproportionately long time. And there are just a couple of other recent developments that are worth mentioning. There's the Civil Justice Council's review of pre-action protocols, Part 1. Part 2 will be on specific pre-action protocols. So this is on the general one, but its main recommendation is the general pre-action protocol will form a practice direction to Part 1, to the CPR, and under it, it's envisaged parties must take 3 steps before issuing a claim: exchanging information, engaging in dispute resolution with an obligation to hold a pre-action meeting if the parties can't agree the form of that dispute resolution process, and completing a detailed joint stocktake form or report, setting out in writing what's been agreed. We'll have to wait and see, but this seems to envisage a sort of almost like a family law situation where you can't actually take a step in your litigation without having gone through some sort of ADR process. The second development is the government response to a recent consultation increasing the use of mediation in the civil justice system. And the policy of integrated mediation is going to apply to all small claims in the county court. So once a defence is filed, parties will automatically be referred to a mediation scheme offered through the HMCTS. And if you don't attend, that will be recorded as non-compliance, and a judge may decide a sanction, strike out costs or whatever else. But what's interesting about that document is the idea of a mediator writing a report confirming that the parties attended and that they did so in good faith and participated that idea was rejected. It said that that would breach the confidentiality of the mediation, and the only requirement was turning up. But it was felt that there had to be some form of meaningful sanction. And this report says the CPR will be amended to enable the implementation of this policy, and that it says in due course this will be rolled out to all claims of higher value in the county court, at least, on the fast track and multi-track. So finally, coming back full circle to Churchill, apart from interesting from the effectively giving guidance on the difference between ratio and obiter, which is of interest, the decision is pretty straightforward. It simply says the court, contrary to the earlier thinking, now has this power to order the parties to engage in a non-court-based dispute resolution process. And it doesn't really go much further than that. Save for 2 points worth mentioning, it doesn't lay down any guidance to the courts as to how they should exercise that power. The first point is the court clearly felt it appropriate to depart from that comment in Halsey, which I mentioned a moment ago, that it thought there would be unlikely to be circumstances in which it would be appropriate to exercise that power. So Geoffrey said quite specifically, I would not go that far. And the second is that the court refused to lay down any fixed principles as to how the court should exercise this. As Geoffrey said, it's undesirable to provide a checklist or score sheet. But those factors are set out by reference to one of the intervening parties, the Bar Council, that attended the hearing, and you can look at that. Now, on that note, I was probably taking too long. I was going to turn to the first of our questions and turn to Ben and ask, is this any of the court's business to impose mediation on the parties? Shouldn't that be up to them?
Yeah, thank you, Michael, and thank you for introducing what is going to be, if Geoffrey Ross gets his way, a seismic change in the way we do business. And just before we look at this issue of principle, which I think we should look at, because the deal is not yet done, it's worth observing what kind of change this is and what magnitude it is. Up until now, alternative dispute resolution has been exactly what it says on the tin. It's been an alternative, and it's been run alongside dispute resolution in the courts, and the courts have not engaged in any way in alternative dispute resolution. And the only interaction the court has with alternative dispute resolution is if somebody makes an application at the end of proceedings for a portion of their costs on the basis that somebody unreasonably refused to go to ADR. And that's been the only interaction you get. And in most courts, even if you ask for a stay at certain times for ADR, the court won't agree to it. The tradition has been very much that it's not the court's business to be part of ADR, and indeed it's not the business of the parties sorting out ADR to be interfering with the court process or involving the court. All of that's going to change, because once the court gets into the business of being able to order ADR and to make it a precondition of proceeding at certain times in the court system that you've gone to ADR, then inevitably, it seems to me, the court's going to be involved in the management of how that ADR works. And that's going to be very different and very problematic, and a new world for all of us. But roll back and let's look at this issue of is this actually an appropriate step for the justice system to be taking? And I'm not going to speak for all of the time. I'm going to certainly canvass your views on this, but I'd just like to make this observation. For whose benefit is this, for this change? Who is this directed to? Who is this going to assist? Because if it's just the parties, it's a very curious way of going about it. Every now and again you see, and Michael read out some of the excerpts from the judgments, the court saying in a rather huffy way, oh, if only the parties had screwed their heads on, they could really have avoided all of this problem if only they'd gone to ADR. And every now and again you get cases like that. But by and large, litigation is a matter for the parties. Whether they want to go to court, how they put their case, what their case is for. And that's part of a larger judicial attitude to what's called party autonomy. You can sign any contract you want, and you can exclude your rights to go to court. If you go to arbitration, you sign up to an arbitration agreement, you exclude the court's interference, and you can do that voluntarily. You can even sign a contract that says you have to go to mediation before you go to court. So the parties are given a lot of responsibility, and the court will not interfere with their choices in their private dealings. So why on earth, I ask rhetorically, should the court then interfere when they decide they want to have a go at each other in court? My suspicion is, and I'd be very happy to see what everybody else thinks about this, my suspicion is this is not just aimed at the benefits it will bring to the parties. This is largely aimed at the benefits it will bring to the justice system and to reducing cost. And that is, I suspect, the driver. It may not be the driver behind everything, but it's a large part of the driver behind the move to make people mediate or come to some other kind of ADR. Now, I'd be very interested to know if anybody radically disagrees with that view. Anybody want to put their head above the parapet and say, no, Sir Geoffrey's absolutely got the parties in mind here? doesn't seem to be a lot of takers. Anybody strongly agree with it? And do they have any personal views as to whether the courts should be going down this route? As a matter of principle, we're going to look at the mechanics in a minute. But just as a matter of principle, is it something that is likely to concern either you or your clients, that they have this kind of autonomy taken away from them and they're told they can't go to court until they've done X, Y, and Z?
I think it depends who you're representing.
Yeah.
If you're representing insurers rather than insured, for example, one might see the insurers might be more willing or desirous to go to mediation from past experience and their own exposure to risk and costs, whereas insureds may not.
Yeah.
But for my money, the moment Jackson brought in his reforms and my life ended as a reasonable litigator, it increased the costs because they were all front-loaded,
Yeah.
which is now intolerable for the justice system itself. And this is one way of clawing that money back, which is disgraceful, I think.
Yeah. And anybody want to echo that view or reflect on it from a slightly different perspective? Yes.
Well, sometimes, sorry. You know, it seems to assume that the only point of bringing a case to court is to resolve that specific dispute, whereas often you might want to establish a precedent so that you can cut down on disputes in the future and provide certainty for all potential parties. So it seems to sort of fundamentally misunderstand because obviously arbitration, for instance, is quite often confidential and doesn't establish a formal precedent. So it seems to quite worryingly misunderstand one of the, important functions of the court system.
Can I ask a slightly different question to do, and where I'd really like to have your feedback, which is to do with the underlying thinking behind this move, which is the assumption that if you make parties mediate, that will increase the number of settlements. And I'm assuming also within this logic, what the Sir Geoffrey Ross means is make them mediate early. And does that strike everybody as a sensible thing to do in terms of simply producing more settlements, or is it just going to lead to delay?
It's possible, I think it will backfire. They'll actually open up a whole area of law and of litigation in a way which increases the court's problems and costs.
Yeah.
And everybody's costs.
Yeah.
But I think it could backfire. If anybody else agrees with that.
There aren't that many good mediators. That's the real problem. A lot of mediators often are just shuttling between rules, saying what the other rule said. That is not going to help.
I think that's an interesting point, Jonathan, because
In commercial cases.
I think it's an interesting point because I think one implication, and certainly it appears in the CJC report, says that compulsion, people might think, is not necessarily going to lead to more settlements, but it found that it's actually trust in the process is the most important thing. And if you're going to integrate mediation throughout the justice system, what's required is probably some form of benchmark about standard of mediators, particularly if they're embedded into the sort of digital justice system that you get a reference to them. So questions about regulation of the mediation profession are coming along.
There must be less than 10. Independent mediators could
Yes.
be less than 10
Yeah.
who actually engage in the issues.
Yeah.
The amount of times I've been in front of the Great Court mediated, often silks and retired judges are quite important as well.
Should we move on to the second question? That was the first one was more about the sort of constitutional. But if we move on to the second question, which was we thought if there is this new power, if the court's going to get involved, when should it get involved, and what conditions, if any, should it set? I think this really was designed to sort of raise the question: is we've all been at CCMCs, and the argument tends to be, well, it's too soon, or it's not going to work, and how is the court? When should it get involved? Have you got any thoughts on that, Ben?
Well, it's difficult because obviously one of the things we don't know is exactly what it is that Sir Geoffrey Voss and others have in mind. Do they have a continual duty to go to ADR, or is going to ADR once ticking the box, as it were, enough, and that's going to be worked out. But one way of thinking about this is to ask yourselves, in the normal court process, when do you get in front of a judge? And there are only two occasions in the normal court process when that happens. One is right at the beginning, effectively, after pleadings are closed at the CMC, and the other is the PTR. And in many respects, the CMC is too early, and the PTR is too late. So I myself, I'm not entirely confident about the mechanics of how this is going to work, and whether, for example, all that will be required is if you turn up at the PTR and you haven't gone to mediation, the court will simply take the trial out, which is one possibility, or whether, by an alternative, when you go to a CMC, the court will say, well, you must, in the directions, have a stay or a period during which you will go to mediation. Yes?
In my experience, I don't think the CCMC is too late. There's quite a lot of disclosure that goes on under the protocol. There's a lot of cost now involved with CCMCs, disclosure review document. So I think, from my experience anyway, I've done sort of defendant and claimant work, prof neg work. That's the right window of opportunity, pre-CCMC.
Anyone else have a view on that? Yes.
I don't know. My feeling impression is that most cases will at some stage be appropriate to mediate, and that's why the vast majority of cases do settle rather than go the whole way through. I'm just not sure that a court or a judge is necessarily the right person to determine when, for any particular case, is the right point in time. Yeah. The claims handlers and the parties themselves will have a better idea of actually, if I'm being told I have to mediate in a month's time, whether I actually think I have the information to do it or my client has the information. So it feels like something where it should be a more general direction that it should happen at some stage prior to X, and then it's then for the parties to ensure it happens at some stage they think is right. But that's just my thought.
Take that. And when does everybody think X would be? Because obviously the parties might say, and you might get one party that says, well, till I've seen the openings, I don't know how this case is going to be argued. I'm not going to go to mediation till the day before trial. So there has to be a sort of sensible point in time, you would have thought, for every case where that would be the backstop. Katie?
You and I and Jonathan spent many years alternative dispute resolution for professional negligence today, which was not mediation. It was adjudication, and that was based on what the construction lawyers know very well since 96. It's been a statutory requirement in all construction disputes to have an adjudication pre-action, which has been known to clear the courts. So whether it should be part of the protocol as a timing, as a pre-action requirement, I'm not really sure why you wait. Why wait? Why not have some sort of ADR in every case pre-action, and then the parties can choose if they want to continue.
Yeah.
And surely adjudication in a deadlock case, mediation is never the answer. I mean, if you've got two experts who are disagreeing, or barristers that have completely different views on the law, mediation is never ever the answer in those cases. The only answer would be something like adjudication, where you get an independent examination, and that has teeth because you can enforce an adjudication decision in court of our summary judgment application as temporarily binding. So those would be my thoughts.
I just wonder what's happened to WP negotiations.
Yes.
When I first qualified thousands of years ago, we were plaintiffs and defendants. We issued our letter for action. We issued the proceedings at the same time as sending WP letters to the opposition to invite them to negotiate over the phone or in person throughout the whole of the preceding, the following litigation itself. And there were many cases settled on that basis, and ADR wasn't even on the agenda.
I'm interested if anybody shares this experience, but I have found that you don't now make offers because you've got a mediation that may happen at some stage, and you don't want to show your hand. Is that the same experience you've all had? And that culture has changed, and I suspect, I'm looking at you, Philip, if you're bringing somebody up, as it were, you're training them, they probably have never experienced the way of doing business that you did, of settling cases over the phone or by letter.
And it's this awful feeling that if you show what's perceived to be your hand, you're being weak. It's just nonsense. It isn't like that if you can talk about it in a sensible fashion.
Yeah.
But the fixed cost regime has changed the claims, or completely the claims under £100,000. And I think you know, if you're looking at advising clients about what can be expensive cases where they recover a very small fraction of their costs, you have to also start looking at other ways for them to have some sort of justice.
Yeah.
Shall we move on to the next question then? This occurred to me, is that if the court has to have this new power, how is it going to decide if an order is appropriate? And picking up your point, what's going to be admissible for the purposes? You know, can you sort of come along to your CMC and say, can I show you what's been said that might be pertinent to whether or not you exercise your power? This seemed quite difficult. And Ben, what were your thoughts on that?
Well, I think it is difficult because although we saw that list earlier of bad reasons for not going to mediation, and that rather prompted the question in my mind, well, would there ever be a good reason not to go to mediation? And if the judge said, well, you must go to mediation, could you ever say no? Because it's hard if the judge doesn't know and can't know what the reality is. It's very hard for you to say to the judge, well, there is actually a really good reason why this is not going to work. It's a really bad idea. Please don't do it. The default position will be, absent some extraordinary circumstance, the judge will order mediation. You'll have to go whether you like it or not, and indeed whether it's going to be productive or not. And I can't see a way around that at the moment, unless anyone's got any experiences or ideas as to how you might deal with this problem.
Just picking up
Why
that.
don't you do it as I was saying, you don't have to mediate.
No, that's true.
You could agree a different form of ADR. Isn't that the whole point of actually the careful way they've worded Merthyr? I mean, lots of people, are thinking it's the case where the mediator's going to make lots of money because that's what the court's going to run around ordering mediation. But there are an awful lot of lawyers, and I know I'm not alone here in this room, who think mediations are potentially pointless, particularly in situations where, as solicitors, you have a duty to fight your client's case, and there is a deadlock point, and you simply cannot advise your client to settle a mediation, but you can say, let's adjudicate, or use ENE, or other form. You can order any form of ADR, and that is, I think, the answer to that point.
Just on that, has anybody had such good experiences of compulsory ENE that they would say, yes, I would go with that? The court can say in any case, right, I want an early neutral evaluation on this case.
Our Southampton office, in the Southampton court, will order an ENE in every case. And although I don't have any cases in Southampton, it's going quite well in several cases.
Who is doing the ENE? And it's a non-binding evaluation, and then the parties look at it and they resolve the differences afterwards. Anyone else had that experience? Or?
I've not personally, but colleagues have had ENE in contentious probate matters.
Yes.
Where you've got two, obviously, families who is mainly individuals who are up against each other. So I think that's helpful for them to have that indication, rather than fight.
So, I mean, is there a mood that compulsory ADR wouldn't be quite so bad if the parties could then select the form of ADR?
They can, can't they?
Well, we don't know that at the moment. At the moment they can. We don't know what the court intends, because one of the difficulties of this process, if the court's going to take control to some extent of your ability to get access to the court and say you must do an adequate form of ADR, it's implicit within that the court will decide what is adequate.
Isn't it the case that the Churchill approach is not to say that there will be compulsory ADR, but that the courts have the power to compel ADR? So
yes.
there would always be a moment where the parties would go to court and say, we would like ADR in this form, and the court would consider it and think, yes, that's appropriate, or no, it's not.
Yeah.
So it's not, I think you can't have a fixed template any more than you can have a checklist. So it ought to be for the parties to retain control of the conversation around ADR.
Yeah.
But the court can then say, I've heard what you both have to say, this is the appropriate form of ADR, and this is how we're going to do it. And that could be at the CMC, would be the obvious moment where you can take stock of what's happened pre-action, and you've got the pleadings there, in effect, and you can take a view of what's the appropriate timing on mode of ADR.
Yes, I think, Katie, picking up your point, Churchill, the wording was quite clear that they don't refer to compulsory mediation, it's compulsory dispute resolution. However, the whole point and the thrust about Churchill is that it said that what was said in Halsey was obiter, and therefore it wasn't binding authority. And Halsey is all about mediation and whether the court can order parties to participate in mediation. So it is new, yeah.
General though, wasn't
Yeah,
it?
yeah. So it is new.
It was a lot more general about the ADR handbook and.
Yeah, I think where I think it may be relevant, just my personal experience, is that you often get cases. Well, if you've got cases where both parties turn up and within we want it in February, but they want it in March, or we want it in Chester, or they want it in Colchester, those sort of differences which can be just managed. Often, and that's fine, what happens is you've got one party going, we want to mediate, and it's outrageous that they won't. Yeah. And the other party sitting there going, we don't want to do it, and coming up with some reasons. I think that's where this power is now relevant, because the court could just say to that person, sorry, now I've got this new power, you're wrong, we're right, it's going to be mediation, and it's going to be like this. That's what's new, I think. And it's really, the question is when's the court going to do that? And just on that, I mean, in terms of recent authority on reasonableness to refuse, I mean, I went through the Garrett case, and that's pretty powerful in demolishing all of the reasons why you shouldn't mediate. And there was another case more recently, a Blackpool Football Club, where the court very much said, just saying you've got a strong case is just no way a good reason. And the only couple of possibilities that have recently cropped up is that if you've got a multi-party case, one party is refusing to get involved, and it may be, well, this is more to do with costs at the end of the case. So if one party said, I didn't mediate because it was never going to work, so we had another party who wouldn't, that may be a good reason to get out of a costs order. But now that's probably going to go, because if you're all sitting in the CMC together, all your parties, the court's going to make an order against all of you. The other case is a case called BT Passive Norse in 2021, where if a party is advancing a plainly untruthful case, that has been held to be a good reason not to mediate. But I think at a CMC stage, it's going to be very difficult to articulate that or get that across. Whereas if at the end of a trial, when you're dealing with costs, and an unsuccessful party says it's completely outrageous, even though they've won, they shouldn't get their costs, and they refuse to mediate, obviously the other party can crop and say the reason we didn't mediate is because you were running a completely untruthful case. And that has been held, but that's not going to apply to CMC. So I'm kind of with Ben. I think when is it never ever going to be inappropriate?
I think it's going to be. I mean, I think you're definitely right. I must say so that if the court said you must mediate, and the party said no, we prefer to do an ENE, then I think it would be pretty obvious what the court would do. Or adjudicate, or adjudicate. Yes. I mean, I don't think the court will be hung up. Yes, that's true. I don't think the court will be very hung up on the type of adjudication, but it will inquire into the quality of the ADR. It'll have to be satisfied that it's going to advance the party's interests as the court sees it. And that's what's going to be new about this process.
It would have to be non-binding.
Absolutely.
Exactly. Otherwise, it outs the jurisdiction of the court.
Yeah, absolutely. Next question I was thinking that crops up is that if the court does make an order for mediation, what's going to count as compliance? And I touched on this in relation to the government paper. Is it just turning up? Is it turning up and doing the usual mantra, we're here in good faith? Yeah. Is it saying something constructive? I mean, how do you patrol it? I'm not sure there are any right or wrong answers. In the government report, as I said earlier, the view was taken that really you can't do much more than just sort of tick the box. Did they turn up or not? And that was about it. But it does occur to me that, you know, how do you patrol compliance?
I don't think you can. I mean, you can sign the mediation agreement saying you're going to turn up and mediate in good faith, but that's a matter to be policed, if anybody, by the mediator. If you turn up with just yourself, as it were, at one party, and someone to take a note, and you just sit there with your arms folded, what's the court going to do about it? The court will never know. It can't know because you can't reveal what happened. And if you were a claimant or a defendant who was determined not to settle at that point in mediation, didn't want to be there, that's what you'd do. You'd incur as little cost as possible. You'd turn up purely to tick the box, and at the same time, you'd be sending a message that you weren't going to budge. And I imagine there'll be a category of claimants and possibly defendants who will conduct themselves in that way. I don't myself see a way around that unless anyone has any suggestions as to how you would get that kind of abuse, as it were, in front of the court.
But it's not abuse necessarily. I mean, one of our colleagues did a talk not long ago about blind bidding
Yeah.
mediation. I went to a talk with some mediators recently where they basically said that they didn't want position statements, that what they expected each party to do on the initial contact from me is give them a bottom line figure. And as mediators, then they saw their role as trying to bring the parties to both their figures. They didn't actually see their role as a mediator as anything more than that. So there is an argument as to whether mediation is actually anything more than a mediator just sitting there trying to do a commercial horse trading deal. So it may be reasonably easy to cross that threshold because there are blind bidding mediation is actually itself designed for parties to agree to a cursory process.
I wonder whether anyone has the experience of going to a mediation where one of the parties simply is there and obviously just to go through the motions and makes no offers.
And we went to trial and they lost.
Yeah, I've had that scenario. You know, parties just been going through the motions. But I think, you know, in terms of this new regime, I think it's fine if somebody wants to turn up, go through the motions, offer nothing, and disappear, assuming that they have risk assessed the claim thoroughly and factored in, you know, costs to trial, irrecoverable costs, and all the rest of it. Then that's entirely their prerogative commercially. But quite often, in my experience, you know, you have parties who just haven't considered everything in the round, you know, haven't looked at the whole piece commercially.
I'll just come back with two observations on that. One is, I think we often see mediation as a sort of it's successful if it settles and it's unsuccessful if it doesn't settle. But I actually think mediation can be useful even if it doesn't settle, because obviously, you know, you can get the mediator you can meet the other side, you can sometimes see the whites of their eyes. You can rest assured that messages are being delivered to the other room by a neutral third party. You can find out bits more of information sometimes as well. So it can be a useful staging post to something more. So
I completely agree with that. I mean, I always say to clients at mediation, you never come away from a mediation knowing less
Yeah.
So
Yeah.
even if you're faced with another party who's put the shutters up, you will always learn something. You'll always be better informed after the mediation than you were before.
Yeah. And then the second thought I had was that when we're looking at this point about compliance, I mean, the party that might be wanting to aching to tell the court, well, you made this order for compulsory mediation, but this lot, they just turned up and they just folded their hands and didn't participate properly. Do they really want to say to a judge, well, let's lift the lid on the mediation without prejudice so you can see the whole thing? I'm sure they won't. And so really, I've come to the only way you can get around compliance is to say, did someone turn up or didn't they? And that's as far as it can go.
It's very important to preserve the without prejudice
Absolutely.
aspect, both in direct negotiation and in mediation or any other form of ADR. That is the difference, and that wall needs to be preserved to protect the parties and allow them to speak freely. And I think the role in mediation is very much to facilitate a conversation, which might result in a settlement, might just result in greater information and understanding, which helps lead to a resolution later down the line.
Yeah, and I would agree with that. And also, I would say this, that in my experience, and I'd be interested to know what everybody else has found, the number of occasions where, although a party said, oh, we don't see any point in coming along, there's no point in us being there, etc., 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 nothing to do with us, the number of occasions when they've actually not participated is relatively few. And if you're looking at cases involving unwilling parties to mediations, generally speaking, they have quite a good success rate. And by success, I bear in mind what Michael said, it's not just settlement, it's getting close, or at least understanding where you're coming from and where the other parties are coming from.
I think that's right. Now, just an example, a case where there was no resolution and frankly no progress at a mediation, but it was due to differences within the defendant camp.
Yeah.
It wasn't that they turned up deliberately obstructing the resolution. It's just that became the barrier.
Yeah. Yeah.
And
Yeah.
the claimant was left out in the cold, probably thinking, what on earth am I here for?
Just got time to look at the last question that occurred to me. Is any thoughts on what sanctions should be imposed? This is left obviously up in the air, but if the court makes an order, you shall engage in mediation, and you don't, what should the court do about it? Should it strike out your claim or your defence? What's the point of having a power to order someone to do something without having some stick to beat you up with it if you don't obey? Any thoughts on that?
Obviously, one of the problems you've got in this situation is that you are effectively denying someone access to the court. They're calling your bluff. Up until this point, you can smooth over that particular difficulty by saying, well, this is all part of the court's process. This is all simply a way of winnowing cases so that those who really need the courts get to them, and so on and so on. But in this scenario, if you give the court the power to strike out or debar because someone refuses to go to mediation, you are effectively shutting the door. And that hasn't been tested, to the best of my knowledge, in any of the European cases, both in the European Court and the Court of Human Rights that we've been discussing.
Surely that would be a breach of Article 6.
I would have thought it's a breach of Article 6. I mean, it is arguable that the court has given the parties the route, an adequate route of access to its dispensing justice, and it's just one party's chosen not to take it. And that's how these arguments normally are put in the Court of Human Rights on Article 6. But I would agree with you. My inclination is that this crosses the Rubicon.
And surely then an unless order would be inappropriate. The sanction should be cost.
That's the sanction you would think.
It's always been talked about, but never really deployed.
Yeah.
And I think the idea of an unless order would be
Yeah. Yeah.
Just got time, I think. I think we're sort of running up against the end of our session. But I'd be very interested to know, on a show of hands, Who thinks the idea of compulsory mediation is a good idea?
Yep, no,
Got
be
one-
brave.
Got a couple of takers?
Yep.
And who thinks it's a bad idea? There's a sort of fairly sizable majority. You'll have studiously noted I didn't put my hand up either.
But also I'll ask this question. Who thinks it might be able to work with a bit of tweaking, a bit of moderation, and a system whereby the only penalty was costs?
Well, look, food for thought. Thank you all very much for coming. I hope you found that interesting. But I think it's 12:40, so we probably need to end there.
Nice to see you all.